I'd like to welcome you all and thank you all for coming to this lecture, Access to Documents in the EU. I'd like to thank in particular our speakers, Bart Driessen, Marc, Maes and Ronnie Patz, and of course our chairman, the European Ombudsman, Professor Nikiforos Diamandouros, for addressing us this evening. And before handing over to them, I'd like to thank in particular Transparency International for all their efforts in putting together this event, which I hope you'll all find very useful. And just one quick reminder to ISEL members and to anyone else, we have the 8th Brian Walsh Memorial Lecture next week here in the Distillery Building on Irish and European law, the limits of sovereignty. The speaker there will be the former Chief Justice Ronan Keane, and the chair will be the current Chief Justice. And I'd like to hand over at this point to the European Ombudsman.
Thank you.
Thank you.
Thank you. It's on. Okay, good enough. Thank you very much. Yeah, I will, if you don't mind, I'll chair, but from here rather than standing up for the time being. I want to very much welcome you to this event. I want to thank the Transparency International for inviting me. I accepted also because, not only because, but also because I am a member of Transparency International in my own country, albeit of course currently I have had to suspend my membership because of my current duties, which do not allow me to be a member of any kind of group, particularly in civil society organizations. But I'm particularly delighted that we were able to get what is clearly a very distinguished panel here. I want to thank my colleagues for agreeing to come, and I will be chairing the meeting. At one point or another, you'll have to be also subjected to a short speech by me, because I'll also be talking a little bit about a few things that from the European Union perspective on the issue of transparency in EU law. So the way we're going to do it, we'll start with Dr. Bart Driessen, who is a lawyer working for the Council, and he'll introduce the subject by talking about the legal framework and recent case law pertaining to transparency. Then we'll go to Mr. Marc Maes from the Commission on decisions and requests concerning transparency. Then I'll go third. I'll talk to you about the European Ombudsman's perspective, essentially the European Ombudsman's contribution, if you please, to transparency in the EU. And we shall conclude, with Mr. Ronnie Patz, who will be talking to us more directly about the utility of Regulation 10 and 1049 from the point of view, I think, of, may I say, civil society?
Please.
Okay. Yeah. All right, good. So, without further ado, I'd like to just turn it over to you to thank you for starting out, and then we're going to take it here. The speakers are supposed to speak at roughly about 15 minutes each. So we're aiming, since we started a little late, we're aiming to conclude this meeting at shortly after 8 o'clock, 8:10, so to speak. So, we'll hopefully have sufficient time for questions and answers after the presentations. Please go ahead.
Good. Thank you, sir. I've been given a rather tall order to explain the legal framework and recent case law on transparency in the EU. I'll do my best to run you through it as fast and decent as I can. There's copies of the regulation back there. I hope everybody has a copy. That might be useful. Transparency in the EU actually started in 1993 when the Intergovernmental Conference that adopted the Maastricht Treaty adopted a declaration on transparency. And this was after the Danish referendum, which gave a no to Maastricht initially, and then there was a sort of realization that something had to be done to make you open up Europe, to make Europe more closer to the citizen, and also to do something about making Europe understandable to citizens. And that led to several different strands of developments, if you want. One is openness of meetings. The Parliament has always worked pretty much in the open. The Council was initially a completely closed body as far as outsiders were concerned. It was a bit of a diplomatic institution, and it has gradually opened up to the general public. By the way, I forgot, whatever I'm saying here, I'm doing on a personal title and not as a member of working for my institution. It's a thing I should have said in the beginning. Then, when the Amsterdam Treaty was adopted in the 1990s, there was a provision added to the treaty establishing the EC, which gave a right to citizens to ask for documents subject to limitations foreseen by law. And on the basis of that, Regulation 1049 of 2001 was adopted, the Public Access Regulation, or simply Regulation 1049. And that is still the framework, or the most important text in as far as public access is concerned in the EU, and text which has been made available on the table in the back. Subsequently, the EU became a party to the Aarhus Convention on access to information in environmental matters. And as a consequence of that, the Aarhus regulation was adopted, which in some ways extended Regulation 1049 by making it, as far as environmental information is concerned, compulsory or obligatory for all the institutions and bodies of the EU, but also added one exception to the right of public access as far as environmental information on breeding places is concerned. I'll come to that later. The next big step is the whole development that led up to the Lisbon Treaty, which did several things. First, it lays down as a treaty obligation now that the Council shall legislate in public. And that's an important provision and an important addition. And this is sort of for the moment, I think, where developments there stopped. The Council of the EU does a lot of other things which are not of a legislative nature, for example, foreign policy, the foreign policy field. And there, same rule does not apply. The Lisbon Treaty also comprised the Charter on Fundamental Rights, which makes or sort of raises the right to public access to the level of a fundamental right in Article 42. Any citizen of the Union has a right of access to documents of the institutions, bodies, offices and agencies of the Union, whatever the medium. But there's another provision in the Charter that specifies that the rights recognized by this Charter, for which provision is made in the treaties, shall be exercised under the conditions and within the limits defined by those treaties. So it's still Regulation 1049 and the Aarhus regulation that you in practice have to deal with. The main features of Regulation 1049, just as a few general principles. First, the regulation foresees essentially three modes of giving public access. One is by publishing text in the official journal of the European Union. Another is making texts public on the internet of the internet register of the institutions. The institutions all have an internet site with a register of documents, and these are, depending on the institution, better or not so good developed, depending on the agency or body or institution. The third mode is by providing a procedure for applying for documents. If the document you're looking for is not made available on the internet and it's not in the official journal, you can request public access to it. The main rule there is that is public access unless documents are public, unless there's an exception provided for in Regulation 1049 or the Aarhus regulation that kind of bars access. But that is the main principle. Documents are public unless there's a reason not to make them public. And that's an important point to grasp. It also means that in principle the exceptions must be interpreted restrictively. Another main principle is that public access is granted on an erga omnes basis. That means if a document is made public in Regulation 1049, it's put in the public domain. And certainly in the Council and in the Commission, it's, I think even in the implementing rules of the Commission, that means that access must then be granted to the document to anybody who asks for it. In the Council, in principle, if the document is handed out to you, we normally put it on the internet site as well, and that means that we give erga omnes access. That means we do not in the Regulation 1049 give privileged access to you but not to you because we like you but we don't like you. That would be discriminatory, and that would be in violation of the whole structure and nature and aim of the regulation. Another major principle is that document requests require that documents are checked individually. That is the main principle. I'll come to the exceptions to it later, but in principle, if we get a request for 100 documents, we have to go through all 100 and check which parts of which documents can be handed out, and if parts can be given out, other parts cannot. We have to give partial access to the parts that can be given out for the whole bunch, and do this document by document, rather than just saying, listen, all of this relates to such and such subjects, which is sensitive, and we can't give it out en bloc. So the main principle is individual checking of documents, which causes a lot of work to the institutions, I must say, but that's the law.